Good evening, Mr. Remova.
Alright.
Hello, how are you?
I'm doing very well. And yourself?
I'm okay, thank you.
Thank you so much.
Okay. Look, it's not even 5:30. We have a minute to go. So let's see how people come in, huh?
No problem. No problem there.
Hi, good evening, everybody.
Good evening, Ra.
I'm Mr. Remova, Mr. Insert van Reenen, and Mr. or Mrs. Ngietu. Okay, guys. Yeah. Well, yes, Mr. van Reenen. Mrs. van Reenen. Hi, Adele. Adele has arrived.
Hello there. How are you?
Hi. Well, thank you. Well, thank you. And yourself?
Good. I'm very well, thank you.
Okay. Okay. Students are starting to stream in now. I think we can record the session in.
I've started. Thank you, Rayan.
Thank you. Thank you, Adele. Okay, guys, what we'll do this evening is we'll continue where we left off last week, which was on the subject of unfair dismissals. And we discussed, a lot of things. Is there anything else that student wishes to raise before we continue? No? Okay. So let me try and share the screen with you. Okay, can you all see that? You all see the screen that I've shared with you? If you can just raise your hand. Good, good, good. Okay. Hope the others can see it as well.
Yeah, it's very clear.
Okay, that's good. I hope the others, Mr. Ngetu and Mr. Mahada, can also see it.
It's Miss Ngetu.
Ah, Mr. Ngetu. Apologies. There's no way for me to know that. But yes, that was presumptuous on my part. Sorry. Let us proceed. So yes, we had a discussion last week, if you can recall, about unfair dismissals and how involved the concept is. And let's just do a very quick recap on where we started and where the story continues. The Labor Relations Act makes mention of three kinds of dismissal. What are those? It mentions three kinds of dismissals. What are those?
May I come in, Prof?
You can, please go ahead.
Yeah, it's unfair dismissal,
Yeah.
automatic unfair dismissal,
Uh-huh.
dismissals based on operational requirements, section 189.
Okay. So basically, this is where we must that's you are partly correct there. The how we understand dismissals, because it becomes so complicated. There's so much. The Act starts off by saying in section 195, Mr. or Miss Van Reen, and can I ask you to just mute your mic because there's a lot of background noise. Can you just put your mic on mute, please? Thank you so much. That's a lot of background noise that I've had. Thank you. So if you wish to speak, you're welcome just to raise your hand and speak. So yes, now section 195 says that we have the right as employees not to be unfairly dismissed, okay? And the LRA makes mention of three kinds of dismissals for us to truly understand what the LRA is saying about unfair dismissals. You mentioned the unfair dismissal, the automatically unfair dismissal, and of a dismissal for operational requirements. Now, it is true the Act speaks about an unfair dismissal and an automatically fair and an automatically unfair dismissal, but an operational requirement is not a dismissal in that sense. Okay, it is one of the substantive grounds or substantive reasons for dismissal. The Act, broadly speaking, makes mention of three kinds: a fair dismissal, an unfair dismissal, and an automatically unfair dismissal. Okay, because it could very well be that you take your employer to the CCMA or the bargaining council, and you show them there that you are an employee and that you were dismissed. Now, the fact that one is dismissed, we cannot. It is only defined in the LRA what a dismissal is, but whether that dismissal is fair or not is another question. So, therefore, if the employer, who now has the duty to show that the dismissal is fair at the CCMA, demonstrates to the arbitrator at the CCMA that we had a good reason to dismiss this person and that we followed a fair procedure. If the employer is successful at the CCMA to show that the dismissal was for a substantive reason and that a fair procedure was followed, then what? What is the position of that employee now? How does it leave the employee? Yes, Mr. Go ahead.
Thank you, Prof. If the CCMA finds the dismissal was fair, it means then the decision of the employer to dismiss the employee is upheld. So it will then mean that that employee remains dismissed.
Correct. So therefore, that is where the LRA makes a distinction between, or makes mention of, a fair dismissal. So that is an example of a fair dismissal. Conversely, if the employer fails to prove that the dismissal was substantively and procedurally unfair, then the dismissal it becomes an unfair dismissal and the matter proceeds on. Okay, so operational requirements doesn't fit. Operational requirements is considered one of the grounds of substantive fairness. Okay, when we speak of substantive fairness, we say broadly, yes, there must be a reason, there must be a good reason to dismiss the person. There must have been a good reason to dismiss the person. And the law, the LRA, reads it in for us and says, yes, good doesn't mean good to you and me necessarily. Good means what is good in law, that the law recognizes as a good reason. And the law makes a broad distinction on those three grounds: misconduct, incapacity, and operational requirements. Okay, so that's where operational requirements come in. It is one of the grounds of substantive fairness. Okay. Can I ask students if they can turn the cameras, and put their mics on mute? Thank you. If you wish to say anything, you can just put up your hand and you're most welcome to make a contribution or ask a question. Okay. And what is the difference now? We now understand a fair dismissal and unfair dismissal, but what is an automatically unfair dismissal? How is it different from an unfair dismissal? What's the difference between an unfair dismissal and an automatically unfair? What makes it automatically unfair now? Yes, sir. Go ahead.
Okay, thank you. Dismissals that are automatically unfair are dismissals. In fact, it's a very broad. It's a very broad category, but it's are dismissals that are relating to. For an example, if somebody is dismissed for participating in a protected strike in terms of the Labor Relations Act, and or is dismissed for reasons related to Section 197 and other grounds. So, but that is a dismissal that is regulated in terms of Section 187 of the Labor Relations Act.
Yeah. Yes, correct. That the LRA has sort of made a special category of dismissals called automatically unfair dismissals, where the right of the party, where the party has got such a clear and entrenched right in the LRA that the law recognizes it very clearly and puts the employer in a difficult situation if the employer has violated that right. Okay, so other than the normal automatically unfair dismissals, where you must dismiss somebody for substantive and procedurally, or rather, on substantively and procedurally fair grounds, over and above this, there is this different category in terms of Section 187. And the point of this is to make it very clear, and it's almost punitive to an employer who violates it. Okay, so as a warning to employers that these are entrenched rights for workers, for employees, and if you dismiss people for these grounds, it will be automatically unfair. Okay, and as you rightly said, Section 187 has got a list of at least 7 or 8 mentions of types of automatically unfair dismissals. We discussed that very briefly last week, and we mentioned there that includes the rights that you exercise in terms of Section 23 of the Constitution, those organizational rights, the rights to associate with other employees, the rights to come together and form unions and parties, trade unions and parties, to have the activities that these trade unions, have together, the right to arrange events and activities, and to arrange strikes and protests and pickets. These are all these things that fall under Section 23 of the Constitution, and the law is very particular. Yes, is that you wish to say something?
Okay. Yes, you do. They know. They do. So I'll keep you informed.
If I can ask you, yeah, please put your mic on mute there. Thank you. So these categories of automatically unfair dismissals are the rights, the organizational rights. So to make it very clear, it is to give workers that assurance at the highest level that you have the right to strike, you have the right to stand up to your employer, even to the point where you can go and strike. And you have these enshrined rights, and you mustn't feel afraid to exercise them because of the fear that you may be dismissed. And if you are dismissed for this ground, you have a very good remedy in the form of the automatically unfair dismissal. So most of these rights, they center half of the rights of automatically unfair dismissal relate to this. So it covers even the workers that are not directly involved in the strike. Many times, it takes courage to form a union, to come together and to oppose your employer in a legal way and in terms of law. So the law wants to encourage this so that you can engage the employer lawfully and discuss with him and to negotiate with him on matters of mutual interest. Okay, matters that are involving the workplace, that are matters of mutual interest, which includes things like our pay, our working conditions. So that in the end, the whole idea is, as we know, for the parties to come to sign a collective agreement so that they can actually come to an agreement and record this agreement. The agreement is given a high status in terms of the LRA, in the sense that it will even supersede other provisions of the LRA and the BCEA if it is above the minimum prescribed conditions of those laws, of those acts. So what about the case of people who are not involved in the strike and when they are asked by the employer that your other workers have gone on strike, you must now do the work of the people that have gone on strike, and if you refuse to do that, then you are dismissed because of that. That is also an automatically unfair dismissal. Even during the negotiation process, when an employer, forces you to accept a demand in terms of a collective agreement, and you refuse to accept the demand and you're then dismissed, that is also an automatically unfair dismissal. See, this is where the employer believes in their minds that we hold the upper hand. We will give them an offer. They want a 20% increase. We shall give them 12%. And tell them that if they do not accept it, that we will dismiss them. A common thing. Okay? It used to be very, very common, and still in certain areas, some employers try and get away with this. But the LRA says that no, in such a case where you were forced to accept something, the failing of which would result in a dismissal is a ground for an automatically unfair dismissal. The other thing which we spoke of was about last week, the pregnancy issue. I think, did we not discuss that issue about the test? The question we did in class was about that lady going on maternity leave, remember? Is that the example we discussed in class last week? And we mentioned that, you know, when a lady takes maternity leave and she is, you know, dismissed even for intending to become pregnant. She may not even be pregnant, but even an intended pregnancy, a dismissal related to that could be an automatically unfair dismissal. Okay. Then there's the unlawful discrimination grounds that is automatically unfair. There is the protected disclosures. There is the transfer in terms of section 197. Okay, all those particular categories. So it's important. I exam paper before where they actually ask you to list, you know, what the kind of or types of automatically unfair dismissals there are, and you do well to know that. Now, we were talking about the kinds of substantive dismissal now, the grounds of the substantive dismissal, which is misconduct, incapacity, and operational requirements. Yeah. Now, by far the most common kind of dismissal that you will find at the bargaining councils and at the CCMA is, what do you think it is? Why do you think people have referred unfair dismissals there? On what particular ground? What do you think is the most common one out of all the substantively fair grounds? What do you think the most issues are about? Yeah.
Yes.
Go ahead, yeah.
Okay. The most popular or the common dismissal, effective dismissal, is the one that relates to misconduct.
Yes, that's true. Okay, I would say, you know, probably 80%, even as high as 80, maybe a lot more, you know, is related to misconduct. And misconduct is where, as you know, it is where the employee rather, the worker, the worker, your employee has done something which has been, you've broken a rule. And the rule is such that it warrants dismissal. Now, bear in mind that, you know, the South African labor laws are set up in such a way to protect an employee and to protect his job. Okay, so dismissal is seen as the last resort after having tried many other options, many other avenues, because we, in our labor laws, when it comes to disciplining people in the workplace, believe in a system of progressive discipline. Okay, is it impossible to be dismissed on the first charge of something? Do you think it is possible to be, you know, substantively fair to dismiss, give someone the sanction of dismissal even for a first offense? Is it theoretically possible? Yes, Mr. Mai Benati.
Thank you, Ryan. Yes, it is indeed possible. It depends on the type of misconduct that a person has been accused to have committed. Because, for an example, it may be your first time, but you have are accused of assaulting a manager. So that's a first-time offense. That's, in fact, you are all. It's a first offense, and you have never done anything before that, and you may be dismissed for that, and that dismissal may be found to be fair.
Yeah, absolutely right. And it all depends on the nature or the type of misconduct, active misconduct. Okay, and this is how we apply sanctions, punishment. All right. So when it comes to you know, dismissals for misconduct, we have to ask ourselves these questions that the arbitrator, the labor, even the labor court, if it should be taken on review, needs to ask when it's faced with a misconduct dismissal. And these are the typical questions. So you would ask, firstly, now remember last week we mentioned that every employer would be well placed and be quite prudent on their part to have policies in the workplace, right? So when it comes to the issue of discipline, when it comes to the issue of misconduct, the employer should make it very clear what is acceptable conduct in the workplace. An employer who fails to do that makes it then difficult to dismiss an employee if he doesn't bring it to the attention of the employee, what the rules of the workplace are, what is acceptable and what is not. Okay? Because we will see later as we answer these questions. Firstly, they will ask this question: did the employee contravene a rule or a standard regulating conduct in or of relevance in the workplace? Okay. And typically, the only way to know this clearly, to answer this positively, is to say, well, here's our disciplinary code. These are the offenses here, and these are the sanctions that go with it if you found guilty. Late coming, it's a sanction. It's something that is an offense. It's considered an act of misconduct, but it won't necessarily and won't reasonably ever, invoke dismissal for the first, second, perhaps even third time that it is committed. Okay, so the rule must be known. That's the first question. If it is some obscure rule, the more that's difficult to answer this question. It will be therefore difficult for the employer to prove that it was substantively fair now. Secondly, if that rule was broken now, was the rule valid and reasonable? So although the employer is entitled to say in his workplace what may be considered to be reasonable, or rather to be the rules of his workplace and the conduct rules that he requires, any rule, it cannot be sort of a ridiculous rule, or the test is reasonableness. Okay, reasonableness. Imagine you were to have a rule that if you were to be pregnant in the workplace, and you will have to go. You have to be, it will be considered dismissible. Obviously, that goes against the LRA. So that is not allowed even. So the rule must be reasonable. Secondly, was the employee aware of the rule, or could he reasonably be expected to have been aware of the rule? Right, we've answered this question already. Sometimes if the rule is not clear, some rules don't even have to be written, but it is accepted that that kind of conduct is not right. And therefore, the second question is there: if the employee wasn't aware, could the employee be expected to be been aware of the rule? Okay. And this is typically like with using company facilities and things like that. But the more you codify, the more you give notice to your workers, your employees of offenses, the more difficult it becomes for the employee to get out of it and to say that they don't know about that rule. Okay. Fourthly, was the rule consistently applied by the employer? And this is a major thing. An employer therefore needs to be consistent, because one of the main things, you cannot, because when you are an employer, a boss, you need to treat everybody the same. If one of your relatives work for you and they get caught, with having committed an offense, but you don't apply the type of discipline that you should, as you say you would, and then another employee gets, in trouble for the same offense, that employee is well within his rights to say you're not applying this consistently, and therefore it won't be an appropriate punishment then to give to me because it is never applied consistently. Okay, in the same way also, You know, for example, lesser offenses, you know, coming late, perhaps even, you know, like lesser offenses. You would also then have to be clear about the type of chances that you give a person. So if the code says that the person that comes late should be given a verbal warning, a second verbal warning, a written warning, and a final written warning. And then lastly, you know, it's dismissal after a hearing. Then you need to apply that very consistently. If you perhaps, you know, gave one employer all those chances, as you said in your code, but then you want to dismiss somebody on the second or third offense for that, and then they could very well raise the point that the dismissal, you know, is substantively unfair. And the last question, is the dismissal an appropriate action for the contravention of the rule? Now, this, of course, will depend on the particular circumstances and facts of each case. Okay? Because we use a progressive system of discipline, this question will now be a big thing. You know, remember, what does the LRA say? That if it finds that the person was unfairly dismissed, you know, and then what must the arbitrator? What is the first order that the arbitrator must consider in an unfair dismissal matter? And it's the employers failed to prove that it was fair. What must the arbitrator, when it comes to remedies now? We're going to discuss it later this evening. All the kinds of remedies that the employer, or not the employer, the arbitrator, and also the labor court have at the, you know, within their power to grant. But now my question is that what should they do? What must they do, in fact, in terms of the LRA, when an employer has failed to prove that the dismissal was substantively and procedurally fair? What's the first thing they must consider? In fact, they must order it, in fact, the LRA says. Well, the LRA mentions that. Okay, yes, sir.
Yes, the primary remedy is a reinstatement. That's what they should order as a primary remedy. And then if reinstatement or reemployment, if that is not a right or a suitable order, then they may order a compensation if the dismissal is found to be unfair.
Yes. Correct. In fact, this is what the LRA says, that the arbitrator must actually order reinstatement. It says it's, you know, peremptory, you know, to use a term in interpretation of statutes, that the arbitrator doesn't even have a choice. He must do it, but it qualifies that. Because in essence, you can't actually force people, right, to do something in that way, to work. Labor is not permitted in terms of the BCEA, right? You can't force somebody to work for you. So the Act qualifies that when it says that the arbitrator must order reinstatement if it says that the relationship between them, unless the relationship between the employer and the employee has now broken down. Okay. What is more valuable, guys? To get some compensation or to get the job back? You know, the job, especially if it is from a good employer, for example, the state, or you know, an established employer, it will be better for the employee to be reinstated. You know, and so therefore, the only time that the arbitrator cannot instate or order a compensation reinstatement is if the relationship is broken down, where either one of the parties do not wish for that to happen. Okay, so the employee may say, I want to be reinstated. The employer And then again, here the arbitrator has got some leeway and some latitude, and you can look at the situation that, in a big company, if you work in a mine, there's like thousands of miners. It's unlikely that there's going to be a situation where the employer can't take you back, so to speak. Okay. However, in some other employment, in some other employers' workplaces, where you perhaps, you occupied a position where you had a job where trust was a vital thing. You worked with clients and you worked with monies and stuff. It now be very difficult for you to go back in the eyes of the employer. So if this breaks up, if neither party wants that, then the reinstatement cannot be, an order like that cannot be made. Okay, so obviously, when I represent people at the CCMA or the bargaining councils, we look at all this. We realize getting the person back, even with some compensation, is the first prize, and we look at these things here. Okay. How long has the person served, the previous disciplinary record, your personal circumstances, the nature of the job, and what happened regarding the circumstances of the infringement itself, what you actually did wrong in your particular case. Okay. There's some debate about what should an employee do. Okay, especially if he's had a hearing. As I'm talking about before going to the CCMA, when there are hearings, it's a question, one of those difficult questions when employees want to know now whether they have committed offenses, they've been guilty of a misconduct. If they come clean now and admit to it. Remember, they can sometimes admit that they did something, but that comes with a risk. If you've been trying to work with, a charge of dishonesty or using the company vehicle without permission or something along those lines, the employer must still prove this now, okay, at that hearing. But do you think, like, if you were to plead guilty, what would be the consequences of that now? Just think about that. If you were to represent somebody one day at the CCMA or even at the disciplinary hearing at work, if that disciplinary code allows for that, for lawyers to come and represent people at their workplaces, would you tell your client to admit the guilt and then try and, when it comes to arguments, when it comes to mitigation of sentence or mitigation of sanction, not sentence, just like in a criminal case, so speak of conviction and sentence. So here's a similar discussion. If I'm going to admit guilt now, would you, if you were to represent somebody in a charge like that, would you advise your client to admit guilt and try and make a case out to your employer that, look, give me a chance now and don't dismiss me? Or what do you think you would do? Hmm? Well, this is a difficult thing. I can appreciate that it is not an easy thing, because if you take a big risk when you admit, to a charge that has been brought against you at work, and then you make your employer's job very easy in the sense that now it's a question of what punishment must I give you, okay? And you open up yourself to that risk and that liability now, that the employer can say, well, okay, I want this person dismissed. I don't want him there anymore. Or at the same time, the employer can see a side of you that shows that you are perhaps honest and that you would like to continue working and you want another chance. Okay, so that makes these kinds of questions difficult, and it all would depend on the evidence that the employer has against you and the possibility, now the merits of the employer being able to prove those things at the disciplinary hearing. Okay, now a very quick word before we're going to visit capacity again and operational requirements, but I need to discuss this evening the procedural fairness ground. Okay, like you said from the beginning, that a fair dismissal is one where the person was dismissed for the substantive reason, and in addition, it was a procedure, a fair procedure was followed. Okay, now what is this fair procedure? It is so important that if you fail to do it as the employer, then the dismissal is automatically unfair. Okay, so here's a little checklist. Can you all see this checklist? Is the wording too small for you, or what? Can you see it? You all see that, eh? Okay. So
can you please zoom? Can you please zoom it, because I can't see anything on my side.
Okay. Let's see. Is that better?
Can you please try again? Once more.
Okay, let's try. Okay. Let's try 120%.
Much better on my side.
Is that better?
Yes.
Okay. How's everybody else? Can everybody else see it? If you guys can, please put up your hand. Okay, Ms. Ngetu, thank you. Right, from Helen. Okay, good. I hope the others, Mr. Amova and Fiona Goliath and Mr. Van Renen, can see that. Okay.
Yes, Prof, I can
You're
see.
fine. Good,
Yeah.
good, good. So let's just go into this now. The procedural fairness is extremely important, because failure to observe that and to comply with a fair procedure makes the dismissal unfair. And just for a moment, think, guys, that this is such extremely important things. Okay, it's such a big thing to the labor world, labor law and unfair dismissals. They cost employers millions of rands. Okay, when there's a mistake, when there's a mess up, when there's no observance or compliance with the laws, employers know that to get rid of employees is a costly exercise. So they should know that they should do it right. So how does it work? What is a fair procedure? We now understand substantive fairness. That must be a ground that is good in law, either misconduct, incapacity, or operational requirements. And for each of these substantive grounds, you must also follow a particular procedure. So let's examine misconduct as a starting point. We're going to come back to incapacity and operational requirements. So just like, who is familiar with criminal law? Who's done criminal? Who have you done? Okay, Kenneth has done it. Anybody else? Okay, Ms. Ngetu's done it. Okay, okay, that's good to see most of you have done it. So, if ever there was an analogy, a civil analogy with a criminal system, it is like labor law and like a type of the disciplinary process. Let's do that as we go along. Now I'll use that as an analogy and as a way to measure it. Okay, it's not the same. It's quite similar, but not the same. For example, in criminal matters, it is the state that is always the party that is involved, that charges you. But in employment law, it's your employer that charges you, right? You know the rule of that, you know, the principle of legality, that, you know, you can't be charged for a law that you don't know, and the law must be well known, and there's, you know, culpability, you know, mens rea, that you must be able to prove that the person is capable of committing a crime. In civil, in labor law, similar things. Okay, you must be proved. In criminal law, you must prove the state must prove the accused's guilt beyond reasonable doubt. In any civil matter, including a labor law matter, the employer, and later on at the CCMA, all things must be proved on a balance of probabilities. Okay, so when you accuse somebody, you charge somebody, the state charges you, they must convict you. In the same way, that means, what does conviction mean? That they must find you guilty of a particular offense, as they have had in the charge sheet. In a similar vein, not the same, the employer must charge you with a rule that you know about in terms of the disciplinary code, and must now prove that you are guilty of this at the disciplinary hearing, okay, on a balance of probabilities. So before you even, and let's go back to our chart, and before you even thinking of charging anybody, the police also, they have to, and an employer also, what they should do is, they, especially in large organizations where there are many employees, the employees doesn't have such a tight control and don't have intimate knowledge of what's going on always. So they hear stories or they get reports. So even so, they must conduct an investigation. Okay. They shouldn't just hurriedly, if they do so, they take the risk of not being able to be successful at the disciplinary hearing. So number one, an investigation is very important. It's like the policemen, the investigators, the IOs, the investigating officers, they conduct investigations, they open up a docket, they prepare the docket, and they send it off to the, you know, the prosecutors to make a decision on whether it is, you know, doable. It's, they can open up now a you know, a formal case against the person and start the process of charging them. So an employer should conduct proper investigation to make sure that there are grounds for dismissal of the person. Okay, that is how it should actually be done, and that is why sometimes this is where suspension. You know, we spoke about suspension, precautionary suspension coming up, where an employer may suspend you pending an investigation being finalized. And that's sometimes important, that the employee not be in the workplace while the investigation is being conducted. But nonetheless, this puts the employer in a good position to see whether there is a case. If they have done an investigation and they did the time to do that properly, then they would realize that, okay, there was actually perhaps no truth in all these allegations after they look at the evidence. Or the opposite, that after they investigate, you know, they actually come to evidence, proper evidence, in the form of, you know, witness statements, documents, you know, footage, media, whatever it is, confirming that the allegations are true. Okay, and armed with that, you should now have a hearing. Now, ideally, in large organizations, every organization should have a code, like I mentioned, a disciplinary code, and in this code, it should also tell you how disciplinary hearings are to be conducted. It may even give details about how investigation should be conducted. You know, in smaller employers, in smaller organizations, it's not always so formal. If you work with the state, you will realize that this is an involved process. There's policies, there's procedures, there are HR managers that are tasked with this, you know, to carry out. They, in fact, do the disciplinary hearings. They conduct the investigations, or get others to do the investigations, and they conduct the actual disciplinary hearings. Okay. Now, once you've completed your investigation, you now can see whether you're going to charge. And if you decide to charge the employee, you need to have a disciplinary hearing. Okay, and many people think that, when I've seen this happen many times, that a client comes to me and he says, I just received a letter that they told me, the management told me that they had a meeting. They were talking about what I've been doing. Something they're accusing me of, and they had a meeting, and at this meeting, the executive decided that they were going to fire me. So yeah, I just got a letter now saying that I'm dismissed. Okay. Now, many people confuse that with a hearing. That is not a hearing where the management sit together. They've only heard one side of a story. They've not heard your side of the story. And based on that information, without hearing you, they make a decision. Okay? And that would be substantively unfair if you were dismissed for that. Where management makes a decision. They don't hear you and don't call you to a hearing. So you're entitled to that hearing. An employer must have a proper hearing. And the hearing, you must be given notice of that hearing. Okay. Now, the notice itself is, it varies from code to code, but it must be reasonable. You must be given time to appear. Okay. A reasonable time could be anything from 5 days to 10 days to 14 days. Okay, depending on how big the organization is and how busy they are. But it must be some kind of reasonable time, also depending on the complexity of the matter. But it must be some reasonable time so you can receive this notice. And this notice that you receive, must tell you when the disciplinary hearing is going to be held, what time it's going to be held, that you are being charged, and at this hearing with the following charges, and there should be a list of the charges that you are required to face. You should be told, and your rights are that you have the right to be there, and you should be there, that you may even be assisted there by a shop steward or a fellow employee at least. Some disciplinary codes, not all of them, even allow you to get someone from the outside, like a lawyer even, to help you there. And not all places, it's not compulsory by law, but if that is the case, that is your right, and it should be there. So everything the employer needs to follow in accordance with its own disciplinary code for procedural work as well. If the employer didn't have a code, but did just hold, a hearing, it doesn't make it invalid. Whether it is a reasonable or a fair procedure that was followed, if you dispute it, will later on be decided at the CCMA if you take it there afterwards, if you are dismissed. So you must be given enough time to prepare. You must be told that you'll be witnesses. You can also, if you have documents that are being relied upon by the employer, you can insist that, very well, give me copies of all the evidence and the documents that you're going to be using at the hearing. That you cannot prepare properly. This is not a fair thing. Many employers do this. The first time that they see an employee who is called to a disciplinary hearing sees, the evidentiary documents, is at the day of the hearing itself. And now they need to, answer, which is, arguably not a fair procedure. So you can ask, give me the information, the letters, the correspondence, whatever it is that you have that you're going to be using at the hearing. And everything goes in accordance with the code of the employer. And once you are there, you're entitled to hear the evidence. You're entitled to cross-examine the evidence, to question the evidence and the witnesses. You can also bring your side of the story. Okay, and you can also challenge the independence or the bias of the chairperson. That's possible. If you feel that the chairperson is somebody that has got an interest in the matter or cannot be objective in deciding your disciplinary hearing, then you've got proof of that, then you can object to that as well. Now, after the hearing, arguments are made as well. and then the disciplinary chairperson. That's what they call. They call chairpersons of the disciplinary hearings will then hear the case. He may also ask questions for clarification and then make a decision. Okay, basically be the findings of the chairperson. And the chairperson must now find on two things. The first thing they must find is the employee guilty of the charge that has been brought against him, right? Based on the evidence that was presented before me. Were they or are they? Is the employee guilty of the charge? And then another, yes, Mr. Morris, you've got your hand raised. Mr. Morris?
Sorry, I think that was done just incidentally. Let me lower that. Sorry, Chief.
Not a problem. Okay, so yes, so the chairperson should now make that finding on whether you are guilty of the charge or not. Okay, and after that, you also have an opportunity now to, the chairperson should now also make a sanction, impose a sanction. Okay. Now, this is where it gets a bit hazy. Many times the chairperson is a person that's employed or paid by the employer now who's busy disciplining you, and his independence and his objectivity can obviously be skewed because of that. And then one is free to challenge that, so as far as one has evidence. And then a sanction must be imposed. All right. And once the sanction has been imposed, it could be dismissal. It could even be that there's no evidence to prove the charge, and that's the end of the matter. Then the employer's got no further recourse against you in that way in respect of the charges, and it goes back to normal. But if they find you then guilty and they can impose dismissal, if the code allows it, and that is it, then you have been dismissed. Okay. What now after a disciplinary hearing like that should happen or could happen? Let me put it that way. What could happen now? This procedure was followed. Okay, it was the hearing. You brought your evidence. They brought theirs. You brought yours. Okay, you argued before the chairperson, and now you get the finding of the chairperson, which is you are guilty. Yes, Mr. Morris.
You can, if the company's policies allows that, you can now raise an appeal. I think you can now start an appeal process if that is, for them the way to go.
Correct, Mr. Morris. That's quite correct. If, as he says there, the policy of the employer, mentions an appeal process, then it would be proper for you to proceed through that appeal process. Okay, in large organizations, especially, one can, there is provisions for appeal processes where an independent person is appointed as the appeal chairperson who now looks at the record and reviews the record and sees whether the employers were, well, you need to appeal, right? So normally when you appeal, you will say, what are the grounds of your appeal? Why did I appeal? I appealed because, look, that was unfair here. They didn't consider this evidence or that evidence, whatever the case may be, okay? And if the appeal is exhausted, what then? And you are dismissed, what is your right now? Where do you go to now? Yes, Mr. Morris?
You can now go to the CCMA, and
how much time do you have to do that?
30 days, I think.
That's right. Now, what happens if you got delayed or something happened? Perhaps you got sick. You were just not able to bring that matter or refer that matter to the CCMA within that 30-day period. Do you then lose your claim to be able to refer the matter?
No, you ask for condonation.
Right. So condonation is where the CCMA has got its own set of rules, by the way, and all the bargaining councils also have their own particular rules of how you must, refer disputes and the way that disputes are handled there. Okay. So 30 days, you got to you file your referral, but if you're outside of those 30 days, they won't normally hear you. So you need special permission to be heard to condone your late filing of your application, of your referral. And the CCMA rules say that, the CCMA official may, if you can show good cause, permit you to file your referral after the 30-day period. Okay. So you take it now to the CCMA. Yes. Just, and then you start now the process at the CCMA, which you guys should know by now, right? Once there's a form that you complete, the 7.11 form, you tick off there the information there, like it's an unfair dismissal. You will put in there whether it's substantive or procedural fairness that you are challenging. You'll briefly put out the ground why you believe it was a substantively unfair or procedurally unfair. Yes, sir. Okay, Mr. Morris, is your hand up a mistake, or do you wish to say something?
I was going to ask something, just going
Please,
up a little,
please.
if you don't mind.
Not at all.
If a presiding officer
Are we talking at the disciplinary hearing now?
at the disciplinary hearing, yeah, sorry man for going back.
No,
If
no problem.
If the presiding officer do not have a letter of appointment, but it's so stated in it's part of the company policy rules that there will be the presiding officer will have a letter of appointment, but the presiding officer cannot produce that letter of appointment. What can the person do who is now being charged or supposedly charged when it comes to the actual hearing?
Well, you see, now remember, every disciplinary code is not always the same. Right? You will find in different workplaces that you have codes that suit those particular circumstances. So if, for example, for a company like Old Mutual, where there are different tiers and levels of management, and depending on your position of your employment, you shouldn't be heard, or your disciplinary hearing cannot be chaired by someone within your department. It needs to be chaired by a person in another department of a certain amount. And if you're a senior employee, it needs to be a chairperson of same or higher rank than you. So this is all in their particular code. But the golden rule is, when you challenge that, is to look at what does the employer's own code say about the appointment and the credentials of the chairperson. So that is where you trip up to the employer. The employer is obliged now, once it has a code, it is obliged to follow that code. And when it doesn't, it makes it almost, I don't want to use the word automatically, but it makes it sort of very easy to show that you haven't followed your own procedure, and therefore it is substantively unfair. Okay. So in such a case, if it is a requirement that it must be a person that's employed or at a certain level, and you challenge that, and you validly challenge it. In other words, it's something that you can attribute to a clause in the code itself. Then you may have something to stand on. And there's two things you could say. You must say, well, look, you are supposed to be the chairperson. The code requires you to be of a particular rank or particular department. We doubt that. Can you please show us that? And if he says he is, and he's incorrect in that, it would make the whole procedure now sort of unlawful. Okay, even if he goes through such a hearing and he finds you to be, guilty, you can use that as a ground on appeal or even at the CCMA later. But the golden rule is we look at the terms of our own policy first to measure the fairness of the procedure. Okay, the second thing is what happens if the procedure itself is unjust or unfair. Okay, the employee is saying, well, I'm doing this in terms of the procedure, the code that we've got here. Then one can challenge that at the CCMA and say, well, they found me guilty and they did this and that, but we're challenging whether that is actually fair or not. And the CCMA can, the arbitrator can make a ruling on that, that whether the application of the policy itself is unfair or not. Okay, he will measure that in accordance with the codes and the annexures of the LRA, which give you the codes of good conduct of or best practices of fair procedure, misconduct, fair procedure, incapacity, fair procedure or fair best practice sexual harassment matters. So all these things are in the LRA, and the chairman or rather the arbitrator has got the right to review and to make a decision to rule against the policy, even if the policy was applied, but the policy was inherently unfair. Okay. Okay, so if it goes to the CCMA now, what's the procedure now? Just to reduce this to, let's say, okay, why is this looking so big now? Can you guys see my screen? Okay, that's better. Can you all still see my screen?
Yes, Prof.
Okay, so now we go on to the procedure beyond this now. You get dismissed, you even went through the appeal process, you now take the matter to the CCMA, you get referred, the matter gets set down. Now, the normal procedure is that you would refer the matter for, what we call con-arb, conciliation or arbitration. Okay. So this means basically that the matter first gets set down for conciliation/mediation, and the parties appear there, and if there is no outcome there, the matter then gets postponed for arbitration. So many employers, because of how employers have also abused this, or they realize that the employee can do nothing at the conciliation and mediation phase if the employer is not willing or doesn't pitch. The matter will simply get postponed to arbitration, where it really, really matters. So what has happened now, that there's been an amendment to the LRA where it says that you can actually set the matter down for con-arb, conciliation and arbitration, so that in the event that once you set it down for conciliation and on that day the employer doesn't pitch, that you have the right as the employee then to immediately have the matter arbitrated within a very short space of time, so it doesn't waste a lot of time. Okay, there's also another procedure in terms of what we call pre-arbitration. So instead, what an employee and an employer can do is that even besides going through this whole process of a disciplinary hearing with your employer, that it is possible now that if the parties agree, the employer and the employee, that the CCMA can arbitrate your matter straight at work. In other words, not at work, but they will sort of bypass the whole hearing in the office or at work, but the whole matter gets heard even immediately through arbitration. So you get a quicker arbitration process, and that is only possible if both parties agree. Okay, that's just something new, relatively new. It was now developed, but normally it follows this procedure that I've mentioned. From the disciplinary hearing, you are unfairly dismissed, you go to refer it to the CCMA, you set it down for conciliation and mediation. If you conciliate and you mediate, now how does that work? Has anybody ever been through that? have any experience of that, how that works?
Yes, right.
Yes, tell us.
I do have that experience. I've attended a number of con-abs at CCMA. Actually, it depends on the type of dispute that you had referred to the CCMA. Not all disputes are eligible for con-abs. Some disputes they are regulated by Rule 17 of the rules of the CCMA, if I'm not mistaken. I think it's Rule 17, 2 and 3 of CCMA rules. Which clearly specifies which matters you may not refer for con-up and which matters that are, when you refer to them, they are automatically con-up. They automatically set down as con-up. For an example, a matter relates to probation. That matter, when you refer it to the CCMA, it automatically gets sets down for a con-up. And there are also other matters. And what happens is this: you will be given 30 minutes for a conciliation. If parties are unable to resolve the matter at that point in time, or at that time that has been allocated for conciliation, you get a certificate immediately indicating that the matter has remained unresolved. And immediately after the certificate has been issued, the commissioner begins with the arbitration.
Yes. So this is in broad spectrum. Thanks there, man. I mean, that is in broad spectrum how these things work. Conciliation and mediation is basically where the CCMA goes out of its way to try and, get the parties to settle the matter rather than go to arbitration. Okay. And it would happen like this: they would consult the parties separately and hear what they want, and then come back, with recommendations to each other. And if they agree, an agreement is drawn up, and that becomes the end, and signed, and that becomes the end of the matter. It was successfully mediated, right? The other thing with this also is we're going to come in a moment to those things that get conciliated and mediated, and that are either arbitrated or not. The other thing about going to the CCMA is legal representation. How does it work? Anybody know? Are you entitled to have a lawyer with you at the CCMA? Yes.
Yes, thank you, Ryan. No, not for every dispute. For an example, a clear dispute of unfair dismissal, we are not entitled to be represented by a lawyer in terms of Rule 23 of the rules of the CCMA. You can represent yourself in those matters because matters, for an example, that are normally straightforward matters relating to a certain type of misconduct. In those instances, you are not supposed to be represented by a lawyer, but a lawyer can make an application in terms of that rule, in terms of Rule 23, in order for that lawyer to represent you during the arbitration or conciliation at CCMA. And that would depend on the commissioner who's presiding over the matter, whether the commissioner accepts or declines the request, or or refuse the request for the legal representation. On the other cases where there is no problem with the legal representation are cases, for an example, a case that relates to unfair labor practice. You can be represented in those cases by a lawyer. Even Rule 23 allows for that.
Yes, thank you, man. That is pretty much how it works here. The thing is, for misconduct hearings, you are not entitled to legal representation as of right when you come to refer matter to the CCMA. Okay? And the fact you're definitely not allowed representation at conciliation and mediation level for misconduct referrals. Okay? Even at the arbitration party of a misconduct hearing, you're still not entitled. You have to apply, as your legal representative will have to apply. And the rule says that the arbitrator, should permit the lawyer if there's no objection by the other side, or where the matter is a bit complex and the party, the employee, is, not such a person that can appreciate or be able to handle their own defense and will therefore suffer prejudice, that the arbitrator has a discretion now to permit the legal representation or not. So what happens in the event that legal representation is declined for a misconduct matter? In my experience, what I've done is that if it is, refused after even I've argued, and, which is, it's hardly the case, it's only happened to me perhaps once in many years, is that you insist, then you will just be here, you won't be the representative of the person, but you will be sitting in on the hearing and you would be just her assistant or the person's assistant. And, not as a lawyer to actively represent, but as a support role. And that is the second best thing, if you haven't been given the right to come on record as an attorney or as an advocate for the employee. Okay, so misconduct hearings, you don't have automatic right of legal representation. You can apply subject to what I've said. For incapacity and operational requirements, one is entitled to have legal representation. From mediation right through to arbitration, should it go there. For unfair, here's a little bit of a twist here, unfair labor practices and unlawful discrimination matters. Okay, now unfair labor practice matters can be mediated, okay, and can be arbitrated upon, unfair labor practice matters. So here you're entitled to get your lawyer. Unlawful discrimination, which is different to unfair labor practices, the matter gets referred to the CCMA and is sit down for mediation. If mediation fails, what happens with an unlawful discrimination matter? It does not go to the arbitrator at the CCMA. It gets referred from mediation, which has failed, to the labor court, who decides, whether to decide that unfair labor practice matters. So all unfair labor practices and all automatically unfair dismissals don't get heard by the arbitrators at the CCMA or bargaining councils, but by the labor courts. So it's a bit, you mustn't get confused. It's simply these one or two things that get heard by the labor court, from the CCMA. Okay, so unfair labor practices, they can be arbitrated, it's only unlawful discrimination matters that get mediated but not arbitrated, unlawful discrimination matters, and automatically unfair dismissals. So you now get heard there, mediation doesn't work, as Mr. Maibinati has mentioned, it doesn't work. The certificate is issued by the mediator that's saying, well, the matter remains unresolved, and the employee can now get a date or apply for a date for arbitration. We're still going on the premises that we're dealing with a misconduct matter here now. So arbitration is a bit different to mediation, eh? In what respects is arbitration different to mediation and conciliation? Yes, please go ahead, yeah.
Okay. Sorry, I muted myself. Okay. Thank you, Ryan. Arbitration, it's where both parties are presenting their side of the story, and a decision that would be made by the commissioner is binding on the parties. It's final and binding on the parties. On mediation, it's a form of alternative dispute resolution where both parties contribute. In fact, there is a person who is appointed to facilitate engagement between the two parties up until, for an example, if they are able, they reach a certain conclusion and in amicable terms, both of them, without a decision being taken by a third party, which will be either in favor of the other party or not in favor of the other party. So in mediation, basically, both parties may leave the room as compromised and have some what is called some sort of a win-win solution.
Yeah. Yes. Yes, that is what the other processes were for. They were, as you said, to try and resolve the matter, with some kind of amicability to it. Some kind of deal was struck. But in arbitration, it is, akin to a formal hearing. Okay. If you've ever been to courts, it's not as formal as a court session, but a different official at the CCMA now presides, and he presides as an arbitrator. He's going to hear issues now. He's going to hear facts, and he's going to, hear arguments, and he's going to apply law. So he's pretty much like a judicial, officer in that regard, to arbitrate this dispute about whether it's an unfair dismissal or not. Okay, so it is quite, witnesses are led. The first thing the arbitrator will ask in an unfair dismissal for misconduct, a misconduct hearing, is the same questions. Were you an employee? Yes. Were you dismissed? Yes. Okay, very well. Now, Mr. Employer, you did, that has been proved. You now show us that it was fair. So now the employer must lead evidence. He'll call witnesses. There will be documents. Testimony will be, led by witnesses, and the rules of evidence apply here in this proceeding. Okay, the rules of evidence apply. So all these things regarding, hearsay, regarding admissibility, regarding the relevance, admissibility, and weight of evidence, all these things can be argued. And this is where it gets a bit technical. Okay. So the arbitrator hears that, whether the employer, did that, and the employee also has a chance to bring their side of the story. And at the end, the arbitrator makes a decision, which is called an award. Okay, it's an award, and the award is binding, of course. And if it's a reinstatement, he must be reinstated. If it's for payment for compensation, there must be compensation paid. Okay, and over and above compensation, they can also make awards over and above compensation for certain categories of losses as well. So, right. So let's say you were dismissed by your employer, and then you brought it there to the CCMA. It went to arbitration eventually. The arbitrator made an award, and the arbitrator felt that no, your dismissal was fair. Okay. Is that the end of the road for you now as the employee? Or even not only the employee, but also if it went against the employer and the employer is not happy with that decision, what can happen now?
Okay, thank you, Ryan. If an employer is not happy with the decision with an arbitration award, or an employer or an employee is not happy with an arbitration award, they may take it on review to the labor court, which would then have to hear the matter and decide on it.
So are you saying that now that is a very particular, thank you, that's correct. We must realize that CCMA awards, the arbitrator's award, is not appealable. Okay. What I'm trying to get at here is that you must appreciate the difference between an appeal and review proceedings. Now, the LRA says that, these awards, once they are made, you cannot appeal them. Now, what is the difference between an appeal and a review process? The appeal process is where you are unhappy with, you believe that there was a mistake on the part of the arbitrator, either on the facts or on the law itself. Okay, you take away the issue, but you made a mistake in that regard. either on the facts or the law. And these awards are not appealable. They can only be taken on review, and review are very narrow grounds in terms of Section 145 of the LRA, that you can only take a CCMA review on award on review if there was misconduct, a gross irregularity, or where the commissioner, the arbitrator, exceeded the powers that he had. Okay, so this is the same review process that you learned in civil procedure. You've all done civil procedure. It's on the same grounds. You know, it is where you're not so concerned about the decision, but the way the decision was arrived at. So you're going to be saying that, you know, he didn't apply his mind, or he was biased, or he committed gross conduct or an irregularity, or exceeded his powers. So those are those four grounds, and within that, you must show that the arbitration proceedings were conducted in such a way that it was reviewable, that it amounted to something in those four narrow categories. And it is a very difficult line. What has happened over here is that over years, people used to, you know, take these awards on review to frustrate employees. You know, because once you take a matter on the review, it suspends the award of the CCMA. It cannot be executed now. And the employer who was happy momentarily, either for, you know, being told that the employer must pay him out compensation or to reinstate him, when they have now formally filed for a notice of review, then it suspends that award, and the employer is now sort of in difficulty until this whole review process is concluded, which is an involved and complex process, you know, and costly process involving you getting the records being typed up and, you know, supplementing your papers, and you're going to be taking that record on review to the labor court on those narrow grounds. You know, so that was abused, and over time the courts have narrowed down the test of review. You know, it will only review things under very strict conditions. They will interpret these provisions narrowly. You can take things on review when there's only like a really gross irregularity or a complete, you know, excess or you know, of the arbitrator really exceeded his powers, or he committed misconduct, or he didn't apply his mind in any way. You know, like a fundamental defect in the proceedings, he misdirected himself in such a way. Only then will the labor courts then consider to review such a thing. Okay. Now, once a matter, let's say you go to review, and the reviews can take up 2 years. Okay. It can take up 2 years to be finalized. Now, what happens in the case where, after now taking a matter on review to the labor court, as you said, the labor court now makes an order that it dismisses the review. It can do two things. Okay, it can either uphold your review application and make a number of orders. It can say, okay, what I want is I'm reviewing this order, go back to the CCMA now and have this whole thing heard again. Okay, or it can even make an order there temporarily and say, well, I've read the whole record of what happened there. I am substituting my order, and I'm setting that award aside and substituting it with a following order, and will then make an order. Okay, or it can dismiss the review if it hasn't found that the ground that a proper case for the review hasn't been made out. What can a party who now has brought the review and has the review dismissed by the labor court, is that also the end of the road now? What can happen beyond this? Okay, Mr. Maib Benati.
Okay, thank you, Ryan. No, that's not the end of the road. An aggrieved party must first file a leave to appeal, a notice for leave to appeal to the labor court, so that the matter may be heard on appeal by the labor court. Sorry, by the labor appeal court, the labor appeal court.
Labor
sorry,
appeal court. Yeah.
Yes,
Okay,
I meant to say that. Sorry.
Yes, yeah. Because the labor courts are provincial divisions. They have the equivalent of the provincial divisions of the High Court. They are, for all intents and purposes, high courts. Okay, and they hear only limited matters. Their jurisdiction is also limited to labor matters. But one can, if one is unhappy with the decision of a labor court, take the matter on appeal to the labor appeal court, which is the highest court in the land in respect of all labor law matters. Okay, the court sits in Johannesburg and will be the highest court. Is there anything beyond that? If the labor appeal court is now, you're unhappy with something in the labor appeal court, is at the end of the road. Yes, Tijani.
Sorry.
No, but hold on. No, wait. Unless anybody else wishes to make it's this is not only everybody should participate if they feel they let's give others a chance also. What would you say if the labor appeal court has made a finding? Is there any relief for anybody then to take the matter anywhere beyond that? Okay, go ahead. Mr. Benatti? Hello? Yeah, hello?
Can I come in?
Yeah,
I don't
okay,
know
go ahead. Yeah, sure.
Okay.
No problem, go ahead.
Yes, if you are not happy with the outcome of the labor appeal court, you can take the matter to the constitutional court as the apex court in the land on all constitutional matters. In fact, now it is an apex court on almost every other matter. Yes.
Yeah. So if it falls within the sphere of those things, yes, one could take it to the constitutional court. Yeah. Beyond that, if it is something within that ambit. Okay. Very good. Now that was a typical, road that a retrenchment, or not a retrenchment, a unfair dismissal for misconduct would take. We now need to very quickly, we can look at this next week, Thursday, because I see our time is up, how operational requirements dismissals and how incapacity hearing dismissals are, how the route they follow. Okay, you can see the route for misconduct is it's, I don't know how you guys have found it, but that's the route it goes. But incapacity hearings can be quite intense and quite complicated and even, drag on for even longer. Operational requirements are not normally that long, but they can also be quite intense and, they're quite complicated in terms of the procedures and entitlements of the parties involved. So in preparation for next week, guys, please look at that. Incapacity hearings, the substantive and the procedural fairness of that, as well as the substantive and procedural fairness of operational requirements dismissals. Okay. Are we cool? So I again remind you guys that you can make use of the link, that was sent for one-on-one consultations if you wish to speak to me about something that you're having difficulty with in the course. Yes, Mr. Morris.
No, sir, I'm cool.
You're cool, okay. All right. Yeah, you must enter your student number in the box, guys, in the chat box, eh? Okay, then I'll see you next week Thursday, unless you guys are, of course, going to send me a message to if you wish to speak to me on a one-on-one consultation. Thank you, guys, and have a good evening.
Thank you.
Bye.
Thank you, Ryan.
Thank you, guys. Bye.